Four, we have covered difference between employee and self-employed. We have covered contract of employment. What are the express terms? What are the implied by court? Duties of employees, employer, and terms implied by the statute. So let's move towards wrongful and unfair dismissal. If employer dismiss the employee unfairly without any reason, so that will be called wrongful and unfair dismissal. And if employee consider his dismissal is unfair, he can file a suit against the employer for damages. And if employee is filing a suit, he need to prove in the court his dismissal was unfair. And if court prove that his dismissal unfair, employer need to pay the damages, or might be employer have to re-employ the employee on its original position. So in case of dismissal, what is the minimum notice period required? If employer want to dismiss the employee, what is the minimum notice period is required? If a period of notice is not expressly agreed, normally agreed in express terms of contract of employment. But if it is not expressly agreed, in contract of employment, the notice period term was not written there. Then ERA 1996 imposes the following minimum notice period. Continuous employment. If employee has worked in the organization from 1 month to 2 years, the minimum notice period required is of 1 week. At least 1 week before dismissing the employees, employer have to inform him. After 1 week, you will be dismissed. If the employment time period is between 2 to 12 years, more than 2 years, but less than 12, 1 week per complete year. If employee has worked for 5 years, 5-week notice period is required. 1 week per year. But if the employee is within the organization for more than 12 years, in that case, minimum notice period required is 12. So less than 2 years employment, 1 week, 2 to 12 years, how many years he has worked, that week notice period is required. If employee is working with the organization for more than 12 months or 12 years, then at least 12 weeks notice period is required. Notice by employee, if employee going to leave the organization, leave the job, he also need to provide a notice to the employer so that employer can recruit any other person to fill his vacancy. An employee with at least 4 weeks continuous employment must give their employer at least 1 week notice of them terminating the contract. If you have worked within an organization 4 weeks at least, so you have to give 1 week notice period to the employer. Wrongful dismissal. A claim for wrongful, unfair dismissal is a common law action. Under common law, employee can sue for damages. For breach of contract, the claim is available to both employees as well as independent contractor, self-employed. The usual rule of breach of contract will apply. Wrongful dismissal occur when employer terminates the contract without giving proper notice or during its fixed terms. The contract of our 2 years and he has dismissed after 1.5 years. So that is also called wrongful dismissal. During work without giving notice period are terminated during fixed term of work. Dismissal without notice is known as a summary dismissal. Summary dismissal means unfair dismissal. Summary dismissal means unfair dismissal. Summary dismissal is usually wrongful dismissal, unfair dismissal, unless the employee waive their right or accept payment in lieu of notice. I mean, if employee said, I also want to leave the job, employer dismissing the employee, and employee say, I also want to leave the job, so I will leave today if you give me 1 month pay of notice period. In that case, if employer terminating the contract, so that will not be considered summary mean unfair dismissal. That will be fair dismissal. So summary dismissal is wrongful dismissal, unfair, unless employee waive their right mean of notice period pay, he is waiving by himself, or repudiate the contract themselves. Repudiate mean cancel the contract by themselves or in fundamental breach. For example, employee did something wrong, he is not obeying the order, he is failed to show professed skills for which he was required to work, mean he's not working skillfully, and serious negligence is involved in negligence, breach of duty of good faith, mean he has obtained some personal benefit from work. So in that case, the summary dismissal will not be unfair, that will be fair. So summary dismissal is unfair dismissal. But if employee waive his right, mean he's saying, okay, I want to leave by myself, just give me 1 month pay, in that case, that will be fair. Or employee himself repudiate the contract, mean he didn't perform according to the contract, he didn't perform his duty, contractual duty. Like he is not following the order, he is not working with the skills, he is involved in serious negligence at work, or he is not working in good faith. He is not performing his duty properly. What could be the remedies in solution against unfair dismissal? An individual who believe they been wrongful dismissed may sue in the county court or high court for damages. An employee can sue against employer in the county court or high court. The limitation period for such a claim is 6 years. Mean after dismissal, within 6 years, you can file a suit, not more than 6 years. Alternatively, if they are an employee, they can bring a claim to the employment tribunal, provided they do so within 3 months of the dismissal and the claim is for 25,000 or less. So if the claim is less than 25,000, they can file a suit in tribunal, but within 3 months of dismissal. But if the claim is above 25,000, they need to file a suit in county court or high court within 6 years of dismissal. Mario is entitled to 1 month's notice. Mean employer will give him 1 month notice. Consider both of the following situation and state whether he has been wrongfully dismissed or not. The employer dismissed Mario on 1 month notice, but give him no reason for the dismissal. Unfair, because you need to provide him the reason. The employer dismissed Mario without notice for fighting in the workplace with another employee. Yeah. It's fair. Even the first is also fair if you don't give the reason, but you have given 1 month notice period. After 1 month, your services are not required. Even that is also fair. Yeah. With the notice period, so that you can find other job. But he can prove in the court like I was dismissed without any reason. Or for fair dismissal, employer have to prove in the court that the dismissal was fair. I mean, it need to provide some reason in the court. Unfair dismissal, there is a statutory right under the Employment Right Act ERA 1996. Only employees can bring an action for unfair dismissal. Employer cannot take. Employee, if considering his dismissal is unfair, he can sue the employer because he's having right to. Law providing protection to the employees. The employer terminates the contract without justifiable reason. That is unfair dismissal. There is a procedure. If against unfair dismissal, you are going to sue the employer, there is a procedure. What is the procedure? Must be continuously employed for 2 years, mean you are working with the organization from last 2 years. Must serve grievance notice of an employer, mean you informed that you discussed, communicated with the employer like your dismissal is not fair. Mean you communicated with the employer what is the reason why you are terminating my contract, why you are dismissing me, and you have tried to prove your point of view to the employer your dismissal is unfair. Mean you try to realize the employer your dismissal is unfair. Claim to employment tribunal within 3 months of dismissal. But for the claim of damages below 25,000 pounds, employee must prove, obviously, being a claimant, you need to prove your dismissal was unfair. Were dismissed, presumption raised that dismissal is unfair. An employer also have to prove dismissal fair. So either case will go in favor of employee or employer. So employer must prove reason for dismissal. Employer must prove that it is within one or more 5 statutory fair reason. What are those statutory 5 reasons? We're gonna discuss later. And the tribunal must be satisfied that the employer has acted reasonably. I mean, if employer is saying dismissal was fair, so tribunal must be satisfied by the employer that he acted fairly, mean he dismissed according to those 5 statutory fair reasons. If found unfair, it is proved dismissal was unfair, entitlement to reinstate, mean employee should be restated on the job again, or engagement or compensation, mean if it is self-employed should be engaged again, or they need to be compensated. So first, the employment period should be 2 years. You have communicated your grievance to the employer, put the case in tribunal within 3 months of dismissal. Employee have to prove dismissal unfair, employer have to prove dismissal fair, and tribunal must be satisfied according to employee or employer proof. And if dismissal was unfair proved, then employee will be reinstated, re-engaged, self-employed, or employer have to provide compensation. What are those 5 reasons that are leading to fair dismissal? Let's discuss those first. Statutory fair reason for dismissal. Mean these reasons could be considered fair dismissal. So dismissal for one of the following reason is fair unless the employer acted unreasonably in dismissing for the reason given. Mean he should act reasonably. Capabilities, qualification of the employee, if he was not qualified for that job, he is not capable for that job for which he stated while at the time of appointment, mean he showed some fake qualification document. So if employer dismissing, that is fair dismissal. Conduct of employee is not conducting properly, he is not obeying the order, he is not acting faithfully, his dismissal is fair. Redundancy, For business survival, if employer want to reduce labor, like he is going to shut down one of the branch, so that branch employee need to be dismissed. So that is fair dismissal. So redundancy is a fair dismissal. But there are certain rules that you need to follow. Continued employment would contravene statute, mean that employee is convicted. He is a criminal. And if you are employing to criminal, you are contravening the statute. You are working against the law by providing employment to this employee. So if that employment is contravening any of the law, so employer can dismiss. So this dismissal is fair because you cannot provide employment opportunities to criminal convicted persons. And some other substantial reason could be employee performing negligent, he was not working properly. So these are the 5 fair dismissal reason: qualification capability, conduct of employee, redundancy, contravening statute, and other substantial reason. So we have discussed the procedures for filing a claim against unfair dismissal. The requirement to be continuously employed for 2 years is for an employment contract which started on or after 6th April 2012. For employment contract which is stated before this date, this qualified period is 1 year. Type of dismissal, there are 3 types of dismissal. Contract terminated by employer with or without notice, that is dismissal. Fixed term contract expired or not renewed. And if you appointed the employee for 2 years, after completing the 2 years, employee is dismissed. So that is also called dismissal. Obviously, that is fair. And constructive dismissal. What is constructive dismissal? If employee were appointed to work at night, employer forcing him to work in a daytime. According to his contract, he need to work at night. Employer forcing him to work at daytime. Employee have resigned due to wrong act of employer. So this is called constructive dismissal, mean employee was forced due to employer behavior to leave the job because the contract for which he was entitled is not allowing him to work as per the contract. In that case, if employee left the job by himself, so that is called constructive dismissal. He can file suit against the employer in case of constructive dismissal as well. So there are 3 types of dismissal: contract terminated by the employer without the notice or with notice, fixed term contract completed, or constructive dismissal. What is constructive dismissal? Normally, employee who resign deprive themselves of the right to make a claim for redundancy or unfair dismissal. However, Section 95 of ERA 1996 covers situation where the employee terminates the contract with or without notice in circumstances which are such that they are entitled to terminate it without notice by reason of the employer conduct. Mean he left the job due to employer misconduct. So that will be called constructive dismissal. Mean he was put in a position to leave the job. This is known as constructive dismissal, and there is a case in Western Excavating Limited versus Sharp. It was held that an employee is entitled to treat themselves as constructively dismissed if the employer is guilty of conduct which is a significant breach going to the root of the contract of employment. He is not allowing the employee to work as per contract of employment. or which shows that employer no longer intend to be bound by one or more of the essential terms of the contract, whether the employee leave with or without notice, the conduct must be sufficient serious to entitle them to leave at once. However, they must act quickly, for if they continue for any length of time without leaving, mean he worked for 2 years, after 2 years he is leaving, he was not allowing me to work at my contractual hours at night 2 years back. So that will not be considered constructive dismissal. He need to leave immediately. So they will be regarded as having elected to affirm the contract and will lose their right to treat themselves as discharged. Where such a repudiatory mean cancelling breach occur, the employee resign and will have an action against the employer for wrongful dismissal. And there is a case, Donovan versus Invicta Airways. The employer put pressure on the employee and airline pilot. Employee was pilot to take abnormal risk on a flight. While during flight, pilot cannot take abnormal risk. And if employer forcing him to take abnormal risk, and if employee resign, that is called constructive dismissal. The employer did this 3 times in rapid succession. Each time the employee refused, relations with the management deteriorated and he left due to misconduct of employer. The employer had committed a serious breach of contract amounting to constructive dismissal. The employee succeeded in an action for wrongful dismissal. Because being a pilot, he cannot take normal risk during flight hours. Because this can put the risk of other lives as well. Simon versus Doughty Steels. S had been employed to work on a night shift. When his employer attempted to force him to work on the day shift, he resigned. So this is also constructive dismissal. He could treat himself as constructively dismissed because the employer's conduct had amounting to an attempt to unilaterally change and express terms of the employment contract. And there's another case, Kevin Keegan versus Newcastle United Football Club Limited. A football club manager resigned from his position and claimed he was constructively dismissed. Because in his contract, it was written all the player must be appointed to the club through his permission. And they appointed a player without his permission. So he resigned because of misconduct of the employer. So he contended that when he was appointed manager of the club, it was agreed that he would have the final say regarding the transfer of players into the club. The club breached this term by signing a particular player against his express wishes and that he had no options but to resign. The manager had been constructively dismissed and was awarded in the region of £2 million in damages. This is a case of 14 years back. In British Aircraft Corporation versus Austin, a failure to investigate a health and safety complaint was held to be conduct sufficient to entitle the employees to treat the contract as terminated. If employer is not ensuring health and safety policies, laws, and due to some risk at workplace employee leave, this will also be called constructive dismissal. If the employee does not resign in the event of the breach, they are deemed to have accepted the breach and waived any rights. However, they need not resign immediately and legitimately wait until they have found another job. And what was the statutory fair reason for dismissal we have discussed? An employer can only rely on a given reason for dismissal where they knew of it and the date of the dismissal. What are the fair reason? Capability qualification, misconduct by employees, redundancy, employing contravening statute, some other substantial reason. And there is a case Davis W versus and Sons Limited versus Atkins. The employer dismissed the employee and afterward discovered that the employee had been guilty of dishonesty. Dishonesty was not the reason for the dismissal. I mean, when he dismissed, at that time, he was not dishonest. After dismissing, it was found he is dishonest. So you need to prove at the time of dismissal there was proper reason. So dishonesty was not the reason for the dismissal, and therefore the employer could not rely on it in order to justify the dismissal as fair. Mean this was unfair dismissal. Dismissed without reason. Yeah, without reason. After dismissal, he was proved dishonest. He did something wrong. Stevenson versus Goldwater, a technical manager took part in an unprovoked assault on other employee at a company's social function held outside working hours in the company canteen. So this was a fair reason for the dismissal. It was a serious misconduct. Reasonableness of employer on the employee has once the employee has shown they were dismissed and the employer has shown that it was for one or more of the six fair reasons. It is then for the tribunal to decide whether dismissal was fair or unfair. In case of incapability, mean other fair reason. In case of incapability, the employer will normally not act reasonably unless they give the employee fair warning and an opportunity to mend their ways and show they can do the job. And if employee is not capable of performing the work, they need to warn the employee. Then they should dismiss. Without warning, they are dismissing. That will also be considered unfair. Mean they need to be acted reasonably, not unreasonably. In case of misconduct, the employer will normally not act reasonably unless they investigate the complaint fully, mean they are having evidence of misconduct and fairly and here's whatever the employee wishes to say in their defense or in explanation or mitigation. Mean you should give a chance to the employee to explain his situation. If you are not hearing to the employee, not giving him chance to prove himself, then the reason will be considered unfair because you are not acting reasonably. In case of misconduct, you can dismiss, but you should act reasonably. Act reasonably means give a chance to the employee. Try to hear the employee. In case of redundancy, mean dismissing employees for business survival. Business survival mean you are going to shut down one of the branch. The employer will normally not act reasonably unless they warn and consult any employees affected on their representative. Mean before making them redundant, you discuss with the employees. Adopts a fair basis upon which to select for redundancy and take such steps as may reasonable to avoid or minimize redundancy by redeployment with their own organization. Mean you can offer him opportunity, job opportunity in any other place, then you should make it better. Without discussing, without offering other place job opportunity, the redundancy will be considered unfair. Inadmissible reason for dismissal mean what are the unfair reason for dismissal? We have discussed about fair reason, qualification capability, misconduct, redundancy, contravene statute. What are the admissible mean unfair reason? Dismissal for one of the following reason is automatically unfair. This means that there is no need to meet the length of employment condition. The tribunal will also make an additional award for of compensation. Mean tribunal will provide more compensation to the employee. The inadmissible reason are victimization of health and safety complaints or whistleblower. May if any of the employee highlighted health and safety failure at workplace to any of the regulatory body, as employee informed to the body the weaknesses of the employer, and if employer dismissing due to that victimization, so that will be unfair dismissal. Mean he worked as a whistleblower. Whistleblower mean highlighting issues. A whistleblower is a person